Mr. Steele, I am going to hold you still hold you in summary criminal contempt. I'm going to order that you be taken into custody, incarcerated at the Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends.
Wow, that is unbelievable. This is Bob Bianchi here at the Law and Crime Network. We're going to be taking live coverage for the next 2 hours, and you heard it right there. Attorney Brian Steele, who is representing rapper Young Thug in his Georgia racketeering trial, was held in contempt of court on Monday afternoon and was actually sentenced to jail time. We're going to talk about that. I'm talking about a criminal contempt of court. The drama unfolded when Steele brought forth knowledge of an ex parte. That means a conversation that happened outside the presence of counsel and not in the courtroom. A conversation that supposedly took place before the court began, involving the judge and prosecutors, where the state's witness, Kenneth Woody Copeland, allegedly admitted to killing Donovan Thomas Jr. Before this, Copeland, who is a convicted felon, had finally agreed to testify after having been arrested last Friday for invoking his Fifth Amendment right in front of the jury. Criminal defense attorney Ashley Merchant, who is also the president of the Georgia Association of Criminal Defense Lawyers, represented Brian Steele in trying to obtain his release from custody after the jury was excused. Merchant is representing co-defendant Michael Roman in the racketeering case against former President Donald Trump. Rapper Jeffrey Williams, who is known better as Young Thug, stands accused, along with 5 other co-defendants, of violating Georgia's Racketeer Influence Corrupt Organization Act, also known as RICO. Young Thug is also accused of participating in a criminal street gang known as YSL, which stands for Young Slime Life. Now, this is really, really an unbelievable honor to be able to have Ashley Merchant actually with us right now. Ashley, I got to be honest with you. We said this before we went on there. I knew you are the real deal. I watched you making this argument in court. When your client was first held in contempt, my tweet out to the world was, wow, in all the years as a trial lawyer, with all the friction that's happened between attorneys and judges, I've never seen a judge for something is like this hold somebody in criminal contempt, especially without a hearing and without recusing himself, as he is a witness. These are arguments you very eloquently made. And if anybody wants to know, go to our executive producer, Kathy Russin's Twitter feed or wherever Kathy is, because you can actually see Ashley Merchant making the argument that it's not right. Ashley, last point. As a prosecutor for most of my career, and now as a criminal defense attorney, I don't care what side of the fence I was on, I find this to be repugnant to the administration of justice and chilling to attorneys who are making forceful and efficacious arguments to a court. This judge was out of control in my mind. What's going on down there in Fulton County? Seems to be a lot of arrogance by people in positions of authority. Wink, wink.
I know Fulton County is in its own league at this point. It was shocking to me as well to have a member of our bar, an esteemed member of our bar, which I think you could see if you were watching the live feed. He had a lot of support, but Brian Steele is beloved in our community. He is a nationwide known criminal defense lawyer, has a wonderful reputation. And so we were all honored to come to his defense. It was unfortunate that it was needed, though, because all he was doing was zealously advocating for his client. And what appeared to be the judge being caught doing something wrong himself sort of deflected and said, oh, well, now I want to know who actually outed me. I want you to snitch on whoever it is that told you this. I want to deflect from my wrongdoing and try and turn it around.
Judge, and just for the record,
So Ashley, let's drill down a little bit more about where this began. Okay, so ex parte communications, that is without one of the other sides present, is an extremely unusual and very coveted thing. It's got to be done for specific reasons. But please explain to our audience I've actually had a case where this happened to me. Prosecutors were allowed in chambers with a judge with a sworn witness who now decided he was going to testify. And what was the argument that Mr. Steele was making?
It is unheard of, as you said. Normally we have very specific reasons that you can have an ex parte hearing, and this is not one of them. This witness was in the middle of testifying, had been incarcerated for not being willing to testify. He said he had a Fifth Amendment right to remain silent. He was exercising that, and he spent the weekend in jail. And everyone expected him to come back to the stand Monday morning, testify. All of the defense lawyers were sitting out of the courtroom for a couple hours while the state and the actual, well, he was the defendant in that action, the actual person who was held in contempt, the witness, he was back in closed door and chambers having this ex parte communication about whether or not he was going to stay in jail for contempt or if he was going to testify. That's just unheard of, but ex parte essentially means that the defense is not present. So none of the defense lawyers, Brian Steele and all of the other defense lawyers, they didn't know about this meeting. They weren't able to participate in this meeting. So it was completely ex parte, completely behind closed doors. And they wanted a copy of the transcript. They wanted to know what happened. They wanted all of that information. They're entitled to all of that. What they were asking for is not unreasonable. It's something that they're legally entitled to. And Judge Glanville denied it and then held them in contempt for not being willing to divulge how they found out about his misdeeds.
Yeah, how dare you find out about something we did that wasn't right? And if you don't tell me who told you, I'm going to throw you in jail. Now, we're going to get into and carve out the maybe attorney-client privilege, or the privilege goes beyond that. It also goes to information that goes beyond even what a client may tell you. But we'll get into that in a minute. So do I understand that the gentleman who asserted his Fifth Amendment right, this witness that the government wanted on the stand, was literally in the judge's chambers when this was, it wasn't just lawyers, he was there as well, and the argument is he was being coerced and threatened to testify?
Yes, that is right. And it is unbelievable. I mean, it just sounds unbelievable. Like you couldn't make something like this up. So the prosecutor asked to have this in camera, review where they went back in the court's chambers. They had a court reporter, decided to invite a court reporter, but did not decide to invite the defense, and discussed how long he would have to remain in custody if he refused to testify. So the state had given him immunity for his testimony, but he still said he wanted to plead the Fifth and didn't want to testify. And so they were discussing that and discussing how long he would be held in custody if he did decide not to testify. That's something that the defense has a right to know. That's something that they should be able to cross-examine this witness on if he changed his testimony based on that.
Yes, I was just going to say to you, I mean, the defense has an absolute right for expectation of benefit, or for whatever reason or whatever conversation may have occurred in order to impair his credibility, to bring out what happened. How is the judge possibly, I mean, we can put the contempt aside right now. Is the defense in possession of the transcript and what was said during that ex parte conversation so that the motives of the witness can be explored?
No, and they all asked for it yesterday, and that's what Mr. Steele was arguing about and was asking for when this contempt happened. And then at the end of the day, all of the lawyers again asked for those transcripts. I asked for a copy of the transcript because I thought that it would be important for our appeal, because we're able to appeal immediately, an emergency appeal of the contempt finding. And I thought it was relevant. I think that everybody should be entitled to it. And what the law says is if you inadvertently have this ex parte, let's say that the judge had this ex parte and said, oops, I forgot to invite the defense. The law says you can remedy that by immediately telling everybody what happened. So the remedy is to give them the transcript, and they're still refusing to even do that.
Yeah, so I mean, it kind of makes me think that the judge is saying, all I want to know is the name of the person. Well, that may be the reason the judge said that is so that he can maintain the integrity of the proceedings, but that doesn't mean you don't give him the transcript so he can cross-examine the witness. This is a major faux pas, and as a former prosecutor for probably more than I've been a defense lawyer, I would be very worried that if there's a conviction in this case, that this is a substantial matter on appeal. They are walking through a bad door here. Last point that I want to ask you, Ashley. Now, you made very articulate arguments, and I want you to explain to our audience when you were trying to pigeonhole the judge, and you did such a good job. I knew you were doing it. You were holding your tongue and hope, but you were really getting there about the difference between a criminal contempt in the face of the court that could interrupt an actual proceeding, as opposed to a civil contempt where you're actually trying to force the witness to give information, and that the judge found this to be a criminal contempt. Explain this difference. And in Georgia, explain to me, because at least in Jersey, where I practice law, and I'm pretty sure in New York, if you're going to hold somebody in criminal contempt, you have due process rights, rights to be noticed, you have a right to a hearing, and you have a right to a hearing outside the presence, actually with another judge, because the judge holding you in contempt could be a witness. Talk to me.
Right. And so you know that there's different standards for civil and criminal. So essentially what Judge Glanville was doing was he was taking what was good for him from the civil rules and what was good for him from the criminal rules and merging them. And that's not how it works. You don't get a civil penalty and then follow the criminal rules. So what he essentially wanted to do was he wanted to hold Brian Steele in custody until he talked. That's what he wanted to do. And that's civil. That's a civil contempt. That's something like if, your viewers may understand child support. Let's say someone doesn't pay child support. They can be held in custody until they pay the child support. That's what he wanted to do. He wanted to hold Brian Steele in custody until he squealed, until he talked. That is civil. But he said, well, I'm holding him in criminal contempt. Well, criminal contempt does not allow you to hold someone in custody until you talk. Criminal contempt is a punishment. It's not something that can be remedied. You can't purge yourself. You can't, do an action to get out of it. It's something where you have a certain hearing, you have due process rights. And if he wanted to hold him in criminal contempt, that's fine. Let's just do it the right way. And the right way, it's criminal. It's guilt beyond a reasonable doubt. You have witnesses testify. Someone has to swear on the record about a criminal contempt. It is guilt beyond a reasonable doubt. You have a right to witness list. You have a right to notice of what you're being accused of. He didn't have any of that. He didn't even have a hearing. I asked the court reporter at the end of the day, can I get a transcript of the hearing? And she just looked at me like, what hearing? There was no hearing. It was just this summary criminal contempt without any of the due process. And the biggest thing was another judge should hear it, because who is the biggest witness in the room? Judge Glanville. He witnessed the ex parte. He witnessed this alleged contempt. He is the one who needs to be taking the witness stand and questioned. So he needed to refer this to another judge, and he was just unwilling to do that.
Now, Ashley, you're president of the Criminal Defense Association. Obviously, you're a sophisticated and very, very good lawyer. I was very impressed, like I said. Don't say that often about many trial lawyers out there. Yeah. But I got to tell you what, you got some solidarity, at least from a lot of lawyers up here, myself included. One of my guests that's going to be on the show to my left right now, I can see her vigorously shaking her head in the affirmative. And I think it's a sad day. I think the judge lost his composure. That's what it seemed to me. He got himself and went down a rabbit hole that he couldn't get himself out. But, judges have an authority, but not, in my opinion, that much authority. And I hate to tie these two things together, but I couldn't help but think, there's another incident that's going on down there in your county. And as a former prosecutor who ran an office that had her job, it's not a question of whether there's maybe illegality associated with it. You know better than to do this. You have an instinct never to do something where your propriety can be taken into question. Mm-hmm. So when the judge did this, who I found to be pretty reasonable and doing a pretty good job, it just seemed to me like, wow, there's like a power thing going on down there where people think they can do whatever they want and that there's not going to be any repercussions. Am I wrong to draw those parallels?
You are not wrong at all. Fulton County is a league in its own. I used to be a Fulton County public defender. I've spent the last 20 years litigating cases in Fulton County. It is its own system. And what you're saying is completely accurate. The checks and balances don't always apply in Fulton County. And to your point, this is the same prosecutor's office that Fani Willis runs. She is the prosecutor. Yeah. So she could have put an end to this. Her prosecutors are the ones that did this. Mm-hmm. They are just as liable for an ex parte hearing as the judge. They are the ones, like you said, who have a duty to step back and say, you know what, this isn't okay. This is not how we should be proceeding. And that didn't happen. And I think, it shows the systematic issues that we have in Fulton County and that we have historically in this jurisdiction. And we all thought when Fani Willis ran for office that she was going to fix it because her predecessor had years and years of, indiscretions and issues and things like that. And so we were all very hopeful that it was a new day. But unfortunately, it hasn't been.
Yeah, I have to say it is coming loud and clear to those who are used to a different kind of system of justice mm-hmm. down there. But you know what? When people have always asked me the question, how could you have been a prosecutor and be a defense lawyer? I think you can put this in a box and put a bow on it for the answer as to why criminal defense attorneys, not just the arrogance of power, but tampering potentially and coercing a witness in the substantive case itself. Ashley
right.
Merchant.
Completely.
Thank you so much. Great job. Keep up the good work. And I'm definitely going to be following you now. And on this note, we're going to take a quick break. We'll be right back. Thank you.
Thank you.
You got it.